Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of Mitchill v. Lath. This case was in the New York Court of Appeals in the year of 1928. Let's go ahead and jump into the facts of the case. So the defendant, Lath, had a farm that they wanted to sell. Mitchill wanted to buy this farm. Mitchill liked the farm. Unfortunately, there was an ice house on an adjacent property that the Laths had built, and Mitchill said, I don't really like that ice house. I want to buy the farm from you, but I don't want the ice house to be on the adjacent property. So I will buy the farm from you if you get rid of the ice house. Lath says, sure, that's cool. Go ahead, let's sell you this farm. We'll get rid of the ice house. Subsequently, they enter into a written contract detailing the purchase of the farm. And in that contract, there's nothing written about the destruction of the ice house on the adjacent property. Nevertheless, Mitchill buys the farm, begins to live on it, and after a period of time says, why the heck is that ice house still there? That was part of our deal. And they ask Lath, hey, get rid of the ice house. Lath says, well, that wasn't a part of our written agreement, so I'm not going to do that. So Mitchill takes Lath to court and says, I want to enforce this oral agreement, even though it wasn't a part of the formal contract. So the court is left to consider, should this oral agreement be integrated into the contract, or should it be left out and not considered as evidence into the contract of sale for the farm? So Judge Andrews in the New York Court of Appeals cites the parole evidence rule, and he says that the contract for the purchase and sale of the home was complete and final. Because it was complete and final, outside evidence isn't going to be admitted to bear upon the contract itself. So what he's saying in essence is, we're not going to look to this oral agreement and say that it had any bearing on this contract. Because this contract is complete, final, and integrated is sometimes the term that will be used, we're not going to look to this oral agreement to say that that influenced the contract. We're just going to look to the text of the contract to interpret the agreement. So he puts down a three-part rule for deciding whether or not evidence outside of the contract should be considered as a part of the contract. The first factor, these are three factors that should be considered, was the outside agreement collateral. So this one likely satisfied that. It was collateral because it's collateral that, hey, you get rid of the ice house and then I'll buy the farm. The second was that the outside agreement can't contradict the contract. And the third would be that parties would not ordinarily be expected to include that oral agreement into the actual written contract itself. So Judge Andrews is going to say on factor 2 and 3, there's likely those factors weigh heavily in favor of the Laths, right? Because the removal of the ice house probably would have contradicted some part of the sale in the actual contract. And then finally, a condition that's so serious like removing a full structure should be included in the contract. And because it wasn't ordinarily included there, and it should have been included there, the court's not going to look to the oral agreement. So the dissent says that we should actually consider this oral agreement. And the reason is that the rule of integration sometimes prevents fraudulent claims. So that's where I'm just going to jump into an ex ante discussion. And the dissent is actually an ex post perspective. The dissent is ex post because he's saying, yeah, we have this rule, but it's pretty clear that the Laths were fraudulent. So we should allow Mitchill to recover because the Laths were fraudulent. Whereas Judge Andrews is looking at it from the ex ante perspective, and he's saying that we have this parole evidence rule. And it's important that future contracting parties don't think that outside evidence is going to be introduced into a contract if it is actually complete and final. It's important for those parties to know that the court is just going to interpret the written contract itself and not look to outside evidence and try and just construe and make the contract from the perspective looking backwards to the harms that actually happened. So the ex ante perspective being that it is important that two parties can know the terms they will be bound to when they go into a contract. And they should be able to know that because if their contract is complete and final, that's all the court is going to look to. Whereas the dissent is saying, well, let's loosen up these rules a little bit. Let's remember the reasons for the rule, which is to prevent fraud. And then if we're seeing fraud, maybe we shouldn't follow the rule where it's actually leading us to, basically condone fraud on behalf of the Lath. So that's the case. And those are some perspectives, ex post and ex ante, the dissent taking the ex post perspective, and the majority taking the ex ante perspective. Thanks so much for watching. Hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. And I hope you have a nice rest of your day. Bye-bye.